Happy New Year. It's officially 2018, the end of the first day. So I thought I should go through, count two, the second cause of action, which is defamation, libel per se, and slander per se against defendants Herrera, Kokonos, Burt, and Foundation Digital. So in the last video I went through count one. So now it is time for count two. And what I did, and hopefully you'll appreciate this, is I pulled up, the actual New York cases that establish what is libel per se or slander per se, and we'll measure Maddox's accusations against the law, right? Because that's how you got to win this stuff, right? You gotta see what the law says. I mean, in theory, if you want to win a case, you would look at what cases have won in the past, or you would at least look up what the highest courts of the venue that you have specifically chosen for whatever reason, you would look at what those courts have decided qualifies as defamation, libel per se, or slander per se. Now, a quick rundown in case you don't know. Slander is spoken, right? So if I say that I say a lie about someone intending to damage them, that would be slanderous, right? If I know it's a lie, if it's a false statement. And defamation, or libel, I should say, libel would be written. By the way, I have scotch, right? But I'm not drinking scotch tonight because yesterday was New Year's, and there aren't a lot of people in my house who drink champagne, mostly because just about everybody in my house is children. And I have this 1.5 liter bottle of Prosecco, and I don't want it to go bad. So I am trying to put it down. I've noticed that Prosecco, maybe it's Scotch's fault, but Prosecco does not really affect me. This is like my 4th glass. I don't know. But at least it's tasty. So anyway, maybe it does affect me. I don't even remember what I said. Slander is spoken, libel is written. And by written, it doesn't mean you just wrote it down on a piece of paper, right? You have to publish this in some capacity. So I guess the argument, although he doesn't specifically lay it out, but I think that's probably okay in this case. The slander would be anything that the defendants, and in this case it's Herrera, Kokonos, Burt, and Foundation Digital, right? Anything that those defendants have specifically said, probably on a podcast. Now, it'd be really difficult for Foundation Digital to commit slander because as a corporation, they don't speak much. You would have to have some sort of agent of the corporation acting on behalf of the corporation say something for a corporation to commit slander. And the only defendant here that is accused of slander that's associated with Foundation Digital would be Dick, right? And unless Dick was acting in his capacity as an agent of Foundation Digital, that's not going to be an issue. And I don't think there's any argument that you could possibly make that Dick is acting in any sort of capacity as an agent for Foundation Digital. Mainly because until this lawsuit was filed, you had to search to find out who Dick worked for, what company he was associated with, because he never mentions it on the podcast. And even after this lawsuit, he doesn't like having his company mentioned on his podcast, which is a fine preference, right? There's parts of our lives that we separate from others, and that's perfectly okay. There's nothing wrong with that. And you could find out what company Dick was a part of or associated with prior to the lawsuit. It wasn't hidden information. If you knew his legal name and did a little internet digging, you could find this out. But it's not. He does not hold himself out as an agent for this company in his capacity on the podcast or in any blog posts or anything like that. He actually specifically tends to segregate that. Now, the way principal and agency relationships work, like how you impute the principal with the actions of an agent, would be you have to show that the agent is holding themselves out as acting on behalf of the principal, right? In this case, the principal would be Foundation Digital. Dax Herrera would be the agent. So you have to show that Dax is holding himself out as an agent for Foundation Digital, and importantly, that a reasonable observer would reasonably come to the conclusion that he not only is being truthful in this representation, but he has the authority to act in the capacity with which he is acting. None of these elements are fulfilled. So immediately, we need to just dismiss the idea that Foundation Digital engaged in slander. A more appropriate sort of action would be that Foundation Digital, like as a corporation, engaged in libel, right? This is a possibility if you can show that Foundation Digital or an agent acting on their behalf has published something, which is a little bit easier to show than speaking, because you get into a lot of questions with the speaker, like if the speaker is acting with appropriate authority as an agent. But a published piece, like say a blog post or something on Foundation Digital's website, that would be more of a voice from the business, and that would make much more sense. Obviously, none of that is alleged. I'm pretty sure it doesn't exist. And probably because, like I said, Dick has done quite a bit to separate himself from that company in the production of his podcast. So I don't believe that anything published under the name Foundation Digital exists that involves Maddox. It's possible, I suppose, but in any case, it's not presented in the lawsuit at all. So we're going to ignore flat out Foundation Digital from the outset. Just because of the nature of principal agency, there's no way, there's not even an allegation that anyone is acting on behalf of Foundation Digital in this cause of action. And the parts where they're talking about it in the other cause of action are really weak as well. But in this cause of action, it's not a question that's brought up. It's lazily thrown in there. So let's start here. And this is on page 31. Paragraph 136. The plaintiffs repeat, the plaintiffs apostrophe repeat, replete, and incorporate by reference each and every allegation. Sure. 137. Defendants apostrophe Herrera. I'm trying not to. I really am. Kokonos and Burt published written and oral defamatory statements of fact concerning plaintiff Uzunian and plaintiff Jane Doe on numerous occasions as demonstrated above. Well, we're going to get into that as demonstrated above in just a second. 138. Said statements consisted of associating plaintiffs apostrophe with numerous appalling and false things. What things? And for advocating and encouraging their fans and followers to harass and defame plaintiffs apostrophe and posting reprehensible things. Okay. Defamation has nothing to do with appalling and false. Well, it has something to do with false things, right? But appalling things, harassing things, reprehensible things, those are not defamatory by their nature, right? They have to be. A defamatory statement is a false statement of fact aimed at defending or aimed at destroying someone's reputation and causing them economic loss. Okay? That's a key part of defamation, right? Is economic loss. Because if I just make a false statement of fact and it causes someone no damage, that may be rude, but the court can't do anything to help them. This is why we give money. Like, you take on an economic loss, therefore the court is resolving this issue by providing a compensation, by recovering the amount that you presumably lost. Okay. So these things are directed at destroying plaintiffs' business relationships and their personal lives. Again, harassing is not defamatory. It's just harassing, and it's rude, but that's it. I mean, we're just assuming this is true, right? And we've been through this lawsuit. We know there's problems with the harassment claim in general, or the idea that Dick has incited his fans to harass, right? That's not necessarily a thing that has been shown in any capacity, but let's go on. In indicating other vile things such as having sexually transmitted diseases, encouraging and advocating for rape. All right, let's find out if they did that. Defendants apostrophe published said statements to a third party as indicated above. I mean, I guess just publishing them would be to a third party. These statements appeared on multiple websites and social media, in albums and flyers, and to thousands of people, including plaintiffs' apostrophe sponsors. Oh, hey, that's the right apostrophe. Good job. Defendants' fault in publishing the defamatory statements against plaintiffs' apostrophe consisted of at least negligence. That doesn't matter, by the way. Like, negligent defamation isn't not really a thing. You have to, I mean, it can be reckless statements causing, of defamation would possibly work, but negligence, no. However, as set forth in full above, said statements were published with wantonness and extreme malice. Which, I mean, wantonness and extreme malice, those are legal standards that you have to meet. And we're not even going to get into them. And the reason we're not is because they don't allege how they were wanton and extremely malicious, right? They just, like I said before, this is a legal conclusion. You don't get to just make a conclusion. You have to lay out the facts establishing that legal conclusion. Okay, so here he actually tries. 141. The statements published by defendants regarding defendants' apostrophe regarding plaintiff's apostrophe were categorically false. That's a bold claim. Because you're saying that every statement published by defendants regarding plaintiff is false. Categorically. I don't think that's what you mean. And actually, like, I don't know, some of the statements aren't even bad. So, but whatever. Like, you're saying they're categorically false. Okay. At least that's an element of defamation. And the statements published by defendants' apostrophe were defamatory and exposed plaintiffs to public hatred, shame, obloquy, contumely, odium, contempt, ridicule, aversion, ostracism, degradation, or disgrace, or induced an evil opinion of Maddox in the minds of right-thinking persons, and deprived plaintiff's apostrophe of confidence and friendly intercourse in society. Okay, Maddox. Using a thesaurus to say the same thing over and over isn't helpful in a lawsuit. It's annoying. And a judge or a judge's aide, legal aid, has to read that and probably has to go through, for thoroughness, and pull out their stupid dictionary and look up every dumb word that you're trying to be smart by using. The only time you do this, the only time you lay out multiple adjectives for a specific act is when those adjectives are part of the legal definition, right? Like, public hatred, okay. Shame, maybe. Obloquy, contumely, odium, contempt, ridicule, aversion, ostracism, degradation, or disgrace. Like, you're going beyond the definition of defamation. It pointlessly so. And it just looks stupid and tiresome. For someone who is now 30 pages into your lawsuit, you give them this tiresome task of reading through your thesaurus, trying to flaunt some sort of knowledge. Anyway, the challenge statements or publications have a false and defamatory meaning and tend to disparage plaintiffs in their profession or trade. Now that's important. that is actually getting to the heart of what is defamatory per se. Now, I don't think that Maddox got the memo on what disparaging person in their profession or trade means, but it at least is an element of per se defamation. Said statements are outrageous and untrue and defamatory per se. Therefore, plaintiff's injuries are presumed. Now, what he's getting at here, so if you just allege defamation, okay? If you just allege defamation, you have to prove economic loss. But if you can get defamation per se, then the losses are presumed. So you don't have to prove them at all. In just a second, I'm going to pull up some cases that talk about defamation per se, and we'll see if Maddox has done his job. Plaintiff is also entitled to punitive damages because the libelous statements were published with actual malice, ill will, or spite. No. I mean, maybe. Maybe New York does this, but actual malice, ill will, or spite is actually required because you're a public figure. And criticizing a public figure in a matter of public concern requires actual malice. So you can't, you don't get punitive damages for something that is an element of the specific civil action. Plaintiffs have suffered mental anguish, emotional distress, and extreme humiliation and embarrassment from the defamatory publication of defendants. Further, both plaintiffs' apostrophe have sustained injury to their professional image, brand, and marketability as a result of the publications and harassment campaigns of defendants' apostrophe, and have sustained special damages. Okay. You have to say what they are. You have to lay out what those damages actually are. Like, they cost me this much money in revenue. They did this. Like, this is how you show damages. You can't just say they suffered mental anguish. They caused me to go to therapy for 35 sessions. Those sessions cost such and such amount per hour. They caused me to require medication costing this much money. They caused me to be hospitalized. Those are damages. They cost me an advertising campaign worth this much money. You can't just say that they caused you mental anguish and emotional distress. Like, because mental anguish and emotional distress aren't typically actionable unless you show the damage. Sustaining special damages is great, but you have to show what those special damages are. You have to justify the amount, because the court can't award $20 million for defamation if it didn't cost you $20 million. And if you're talking about mental anguish and emotional distress, those aren't elements of defamation, actually. So that would be a separate claim. Intentional infliction of emotional distress or negligent infliction of emotional distress be a separate cause of action, a separate claim, a separate legal standard, and that's where you would allege the damages from your emotional distress. Defamation is typically limited to the damages that are caused by the defamatory statements, which usually are directly tied to a loss in revenue from business, although not always. Sometimes the damage is presumed. Like, for example, in one case, there was a person who was called a pedophile repeatedly. And actually his nickname around town, and I believe he was a cop or something, he was known as a pedophile, not as like a joke, not as a parody, not as an opinion, but people genuinely referred to this guy as a pedophile due to the defamatory statements of the other party. That guy received special damages. Those special compensation where damages are presumed because being labeled a pedophile is damaging. Like, when the entire community decides you're a pedophile, it's hard to get work, right? Anywhere, because even Walmart doesn't want to hire pedophiles that they know about. So that's the type of special damages that have come about from this. Like, you haven't shown anywhere where you have economic difficulty because of these allegedly defamatory statements. You mention losing a Harry's campaign, but you don't actually really talk about how they're defamatory. And I'm going to get to that in just a minute. We're almost done with the cause of action, then I'm going to go through the evidence that he's presented. Because, again, in your cause of action, you could have linked the specific paragraphs or cited the specific paragraphs where you allege the defamatory statements. And that would be really helpful to a judge or legal aid who's got a 53-page frickin' document to go through. But you don't do that. And I don't know why. I don't know why your lawyer didn't do that, right? Maybe it's because you typed this into Microsoft Word like a dummy and then sent it to a lawyer to sign off instead of having him draft it. Or maybe your lawyer isn't good at drafting these types of complaints. I don't know. I'm not him. And thank God for that. God bless you, Kevin Landau, in your endeavors. I hope they go well. But I don't want to be you. I like being me. All right. No. No, it's gone. Oh, thank God. This stuff is tasty but useless. All right. Where were we? 146. Defendants, apostrophe, published the libelous and slanderous statement of plaintiffs, no apostrophe, woo, in wanton and deliberate disregard of plaintiffs' rights, safety, interests, and welfare. So, and therefore, the imposition of exemplary and punitive damages is warranted. No, that's not even an element of defamation. Like, deliberate disregard of their rights, safety, interests, and welfare has nothing to do with the defamatory statement. And should be assessed against defendants to punish defendants for such appalling and potentially criminal acts. If someone has committed a criminal act against you, call the police. Call the police. Call the FBI if it's across state lines, right? If they're criminally acting in violation of a criminal statute, call police. Don't allege it in a civil complaint without citing the statute that they're violating or without providing evidence of how their acts amount to criminality. And by the way, that's a bad standard for setting... Okay. If you're saying that exemplary and punitive damages are warranted because of potentially criminal acts, you're setting yourself up for failure because the standard for criminality is up here beyond any reasonable doubt. The standard for civil damages is usually based upon a preponderance of the evidence, right? 51%. Maybe a little higher on some things, but you're not at beyond any reasonable doubt. That's a much higher standard. So why would you tie that to your own damages? Because there's no way any of the alleged acts even come close to approaching criminality under any statute. Not a chance. Like, criminal defamation's difficult, man. And you don't want to get into that here because you haven't shown even close. So you're tying your award to a standard that you don't need to tie it to. But anyway, like, the disregard for rights, safety, interests, and welfare isn't part of punitive damages for defamation anyway. I mean, maybe I'm wrong. I don't know. Like I said, I don't practice in New York. I guess they could have some provision in their case law. I haven't seen it, but like, time is money, and I've researched this insofar as necessary to show that this is stupid. Because, I mean, if Maddox had presented enough evidence, maybe it would be worth going further. But as I'll show you in just a second, he hasn't. So defendants apostrophe collectively, and each of them individually, by engaging in the aforementioned acts and or in authorizing and or ratifying such acts, that's not how defamation works. Like, so this is where he's trying to tie in Foundation Digital. Like, Foundation Digital authorizing or ratifying the statements of Dax Herrera is not defamation. Like, that's not a thing. You need to engage in principal agent liability. That's a whole different thing than authorizing or ratifying acts. Like, defamation against you can't bring a suit against someone else you can't bring a suit against Party C if Party A defamed you, right? Like, that's not how it works. Party C has to defame you. So for Party C, being Foundation Digital, to defame you, you would have to then link the actions of Dick to Party C through a principal agency relationship, not by just some authorizing and ratifying. Because, like, Facebook authorized and ratified the statements made by Dick by not taking them down. So did Reddit. Those aren't actionable. You would have to show a principal-agency relationship. You don't do that. And it's a separate standard, right? Like getting... I talked about it before. I shouldn't beat a dead horse. But it's important because, like, the idea that someone authorizes or ratifies an act is one thing. That doesn't cause liability under most civil allegations. Authorizing and ratifying an act is a step away, a big step away from principal agency actions where you impute civil liability onto a principal through their agent. Anyway. Engaged in willful, malicious, intentional, oppressive, and despicable conduct. Here you go with the thesaurus approach again, right? Like, willful and intentional are useless. One of those is fine. Malicious, oppressive, and despicable are all basically similes. You don't need, or not similes, synonyms. You don't need to have all three of them. You're just wasting paper. Electronic paper, I get it, but you're wasting time. And acted with willful, you already said it was willful, and conscious disregard of the rights and welfare of the plaintiff, thereby justifying the award of punitive and exemplary damages. You know what? Give me just... I'm sorry. Let's see if I can find anything... Whoop, dang it. Let's see here. Sorry, I'm ruining my own research tab. Just a moment. Let's see what this says. Punitive damages. I'll drink while I read. Okay. Okay. Here we go. Okay. So this is a case where $100,000 in punitive damages was awarded. And here the court says, likewise, the $100,000 punitive damage award should be reduced. Punitive damages may be asserted in a defamation action. And constitutional free speech protections are not at bar, which immediately distinguishes it from this case, provided that actual malice is proven, as it was in the case Gerst versus Robert Welch. It is our duty, however, to keep a verdict for punitive damages within reasonable bounds, considering the purpose to be achieved as well as the malafides of the defendant in the particular case. We deem the award of punitive damages in this case to be excessive to the extent that it exceeds $15,000. All right, let's see what actual malice... See, now, this is different because these are nobodies, right? The punitive damages in this case... I'm already laughing. Ooh, if I could type, this would be better. I'm already laughing because this case, let me read you the synopsis. It's just funny. Libel action was brought against publisher of magazine article describing plaintiff as a communist fronter, Leninist, and participant in various Marxist and Red activities. Sounds like Maddox. Okay. Let's see. Let me get to punitive damages. In most jurisdictions, jury discretion over the amounts awarded is limited only by the gentle rule that they not be excessive. Consequently, juries assess punitive damages in wholly unpredictable amounts bearing no necessary relation to the actual harm caused. and they remain free to use their discretion selectively to punish expressions of unpopular views. Like the doctrine of presumed damages, jury discretion to award punitive damages unnecessarily exacerbates the danger of media self-censorship, but unlike the former rule, punitive damages are wholly irrelevant to the state interest that justifies a negligence standard for private defamation actions. Let's see. Let me see. Where do they even discuss punitive damages? Okay, so states may not permit recovery of presumed or punitive damages, at least when liability is not based on a showing of knowledge or falsity or reckless disregard for the truth. Let's see. Given such publication, general damage to reputation was presumed, while punitive damages required proof of additional facts. So, punitive damages may not be recovered by showing malice in the traditional sense of ill will. Knowing falsehood or reckless disregard of the truth will not be required. Wait. Hold on. Disregard that. If punitive damages were recoverable upon proof of special facts amounting to express malice. But again, the problem with this is the malice is required as Maddox is a public figure. Also, like, showing malice is... It's not just simply saying that the person is being mean to you, right? Like, that's how malice sounds. They're being malicious. They're doing something maliciously. But malice is a knowing falsehood, right? It's knowing in advance that something is false and specifically asserting that falsehood with the intent to defame someone. That's a high bar to show. You have to show through their actions that they knew something was false. So I think at this point, that's the end of it. That's the end of this stupid cause of action. You know, they ask for $20 million again. And then another, in excess of $20 million for exemplary and punitive damages, attorney's fees and costs. And that the defendants, this is funny, sorry. Defendants immediately retract the statements published and issue a comprehensive public apology towards plaintiffs. Yes, the court will force them to speak. That works well. That goes with the First Amendment just fine. Remove and destroy said statements and photographs relative to plaintiffs' apostrophe from their website, social media platforms, and other advertisements or promotions that exist, and for such other relief that the court deems proper. That's assuming that they deem any of that relief proper. Okay, so I have gone through this document and searched for any instance of the prefix for defamation, DEFAM. So it should get defamation, defamatory, defame, any of that stuff. So the first instance is in paragraph 26, which is on page 5. Herrera encouraged his fans to troll through plaintiff's network looking for clips to take out of context. Herrera, then in coordination with his fans and other defendants herein, spammed Harry's social media sites with defamatory and outrageous accusations against plaintiff Uzunian. Defendant Herrera willfully and maliciously encouraged his fans to contact plaintiff sponsors on his podcast and even justified this harassment. Okay. Further, Herrera posted about it on his Facebook page, calling plaintiff Uzunian a liar and incited his fans by explaining that more hot goss would be coming. Okay, like, incitement. Why? I'm not going to talk about incitement. I'm sorry. Incitement isn't relevant to the charge of defamation, so I'm going to leave it alone. Needless to say, I am going to talk about it. Incitement requires you to incite someone to action. So let's read Dick's tweet or post. It was on your network, Maddox, you lying piece of shit. Both you and Rucka Ali are guilty, you effing cowards. More hot goss coming up. That's not incitement. Like, incitement would be, hey guys, go out and do said thing. That would be how you incite something. Now maybe you're saying that there was an inciting statement, but you don't show it. And we've beaten this horse to death resurrected it through beautiful necromancy, and beat it to death in undeath. So I'm not gonna... Yeah, I'm gonna hammer you on it a little bit. You're an idiot. This is not incitement. Has nothing to do with incitement. Next. Is it defamatory? And that's the real question. Defamation, okay, requires a statement of fact, not opinion. And the standard used would be a reasonable observer. So a reasonable observer to this Facebook post, for example, would have to determine that Dick is making a statement of fact about you. Consider the implications of this. It was on your network, this is what you underlined. It was on your network, Maddox, comma, you lying piece of shit. Period. So, what you're saying in alleging defamation is that Dick is making a factual statement that you are literally a lying piece of shit, which would be a piece of shit that is lying. Any reasonable observer is going to think that that's an opinion about you, not a statement of what you are, as it would defy reality to have a speaking, much less a lying, pile of human feces. Although you may come close to qualifying. The next example is one of my favorites. This is paragraph 35, and this is on page, 9? Yeah, page 9. Numerous examples of Herrera's defamation, vitriol, and incitement of his fans and patrons to target and harass plaintiffs exist. Plaintiffs apostrophe exist. Specific examples are indicated by the red arrows below. So this is... You're saying that there's numerous statements that exist. And you have indicated those by the arrows in this giant Photoshop wall of statements. By the way, pro tip out there, when you're using screen grabs in like this Photoshopped collage, that takes a certain level of skill, and there'd be a real question for the jury if you go to trial. I doubt it. But if you go to trial, there'd be a real question of the jury if you have the technical know-how to not only capture all of these screenshots and put them in a nice collage, and you went through the time to do that, and then to add arrows to this beautiful collage, did you take the time to edit the statements? And I don't know if you did, because Dick has been kicked off of Twitter, and since his account is removed, we can't verify any of these statements. We just have to go by your word on it. So there's an inherent problem with your evidence in that it could be doctored, and we would have no way. I mean, anyone who can clip and add arrows to a collage can probably actually alter the text of any of these tweets. So, problem for the jury. Like, do they trust you because you did this? Not good form. I would have posted each tweet individually in its full glory. Like, each individual tweet, and even with the sub-thread following down from it, I would have put that in an exhibit at the end, right? And why do you have all these other tweets? Like, you put arrows on the ones that matter. Why'd you include a bunch that didn't matter? You're just trying to prejudice the fact finder against the other party. And if you use evidence with less probative value and higher prejudicial value, the judge can disregard it for any reason. Try reading the federal rules of evidence. New York follows the same rules of evidence, so does pretty much every state. So if you have evidence with low probative value, high prejudicial value, the judge should throw it out. This, when you include it all together, this is stupid. If you had included each of the statements individually, like maybe you could have gotten them in. But by including it in this collage, I would move to have the entire collage thrown out. One, it doesn't have high probative value. Two, it has huge prejudicial value because you've included a bunch of irrelevant statements that just make you look bad, so therefore would, I guess the idea, right, your intent would be to prejudice the fact finder against the opposing party. So he doesn't have to. He can throw it all out, and I would move to have the whole thing thrown out. Now, worst case, they're going to keep just the statements you indicated as important and say, why did this dumb idiot include a bunch of irrelevant statements that don't help his case? But let's go through these statements. Now remember, these are defamation, vitriol, and incitement, which is stupid. Again, because you have a cause of action for defamation, you should have laid out those specific statements as defamatory. First one. That's the guy I remember. I think Maddox's bitch girlfriend scrambled his brains. Okay. Is this a statement of fact or opinion? I think it's an opinion, not a defamation. By definition, it can't be defamatory. But if it was, do we literally think your girlfriend is a female dog who scrambled your brains? Like scrambled. Like in Hannibal when he took the guy's brain out. Was it Ray Liotta? Took his brains out and he cooked them and fed them to him. Next statement. Does it lessen your enjoyment of Maddox material hearing what a despicable piece of shit he is? Many such cases. Again, fact or opinion. Are you actually a pile of human feces? Or just a piece. You don't have to be a pile. Sorry, I don't want to defame you. Are you actually a piece of human feces? If not, this is an opinion. Like, obviously an opinion. An interesting late night like on Maddox's leaked convo at Rucka Rucka Ali. You're welcome on the Dick Show. Not your fault your boss is a liar. Okay. Is he saying factually that you're a liar? Or is he stating an opinion that you're a liar? If he's stating factually that you're a liar, what does that mean? Does that mean that every statement you utter is a lie? This is a hard standard to come across. Does he mean you're a pathological liar? He didn't say that. He didn't say you're a pathological liar. He just said you're a liar. 9 times out of 10, like applying an adjective like liar to someone is an opinion, not a factual statement. It's really hard to make that into a factual statement. Let's see. Here we go. Here's your next one. Maddox was raised by gambling addicts. It's the same mental defect that prevents a sorry. Okay. Again. Well, one, were you raised by gambling addicts? Were you? I don't know. I guess that could be defamatory. Maybe. But it's hard to see how you being raised by gambling addicts would be damaging to your reputation. So it fails that aspect of the defamation. Also, if Dick is of the opinion that your parents were, or whoever raised you, I assume your parents, were gambling addicts, that's an opinion. The other thing is that's not defamatory towards you. That would potentially be defamatory towards them. But again, that has to be a false statement. It has to be a statement of fact, not an opinion. If they go to a casino, some people would believe that going to a casino one time is gambling addicts. Hard one to show that that's a factual statement and not an opinion. Same mental defect that prevents a sorry. I assume you're trying to say that the mental defect aspect is defamatory. Maybe not. Maybe you think this one is vitriolic. Mental defect, like, you have to allege a specific mental illness that would be damaging to your profession. And as a podcaster and comedy writer, I don't think any mental defect could possibly be damaging to your profession or prevent other people. Like, even if you're a sociopath, sociopaths might make good comics because they have a bizarre view of the world. A gambling addict comic, probably funny, by the way. Various comics have alleged their own mental defects and have used that to further their career. You being an autistic gambling addict with an inability to say sorry and a propensity for self-bloviation, like, is part of your niche. Like, that's why people like you. You wrote a book making fun of kids' artwork and saying that you are better. Like, that may be a satire, but at the same time, buddy, most people wouldn't consider that. That's what made your view, I guess, mildly unique and interesting on that. Is that you took a view that the average normal person wouldn't have. Again, how is this damaging to you? How is this damaging? I have the full timeline. I will drop more next time Maddox or his girlfriend's behavior displeases me. I guess that's incitement. You're saying that's incitement to the fans, although technically he's asking for you or Metal Jess, Jane Doe's behavior to displease him. So I guess he's inciting you. Because his fans can't control your behavior, so how could that be incitement? The next one. Oh. Maddox is a piece of shit, Chris. He tried to F up a comedian's life over an ex-girlfriend. Alright. Did you do that? You did that. So that's the first bar to defamation. Let's see. There are multiple pages dedicated to real people that were nothing but abusive and harassing statements, including allegations of sexually transmitted diseases, homophobic or racist slurs, and other language not permitted by our rules. Best, Sean M. Wikia, community support. I don't know what that context has to do with anything. I'm guessing it's because he said you're a piece of shit and you tried to F up a comedian's life over an ex-girlfriend. Which, I mean, you did, right? Like, you specifically created a video mischaracterizing Dick's words. Then you disseminated that video to his friends. You published it publicly. You went after his sponsors. You got him removed from UCB Theater. You and your friends did this based on the video that you created that falsely attributed the creation of an 8chan page, which could not possibly be factually linked to Dick Masterson. You alleged that it was him and that he was a rape apologist. Do you remember that? That is where you tried to F up a comedian's life over an ex-girlfriend. And by the way, if you say it wasn't over an ex-girlfriend, then that becomes Dick Masterson's opinion. So again, it's an opinion, not defamatory. Maddox expects friends to act like your family because his family was abusive and he has boundary issues. Those are clearly opinion statements. Clearly, no reasonable observer would say that that's a factual issue, that you have boundary issues. Like, that's a statement you make as an opinion about someone. Next one, spicy bants. Like this one made me laugh so hard. I figured I would put them all in one place. TheDickShow.com, always be trolling, send them in. Okay, we can't see what that says, but that nothing in that statement is defamatory. I'm guessing you're saying it's incitement. Okay, incitement for what? Incitement to have banter with you, maybe? That's not illegal. Your last one. Lakembra, only Maddox related. What? I don't know what that... Okay. Next. Here. We go all the way to paragraph 72. Defendant Coquinos then subsequently updated this post and offered incentives to his and Defendant Herrera's followers to help publish a book defaming and harassing plaintiff and have it published on the same day as plaintiff's own book to interfere with its success. All right. I'm going to read this post. I'm going to read this post from Asterios Kokonos. Oh shit, this is really effing funny idea. I'm going to do this ASAP. Edit. Okay, publishing a book costs money and takes about a month. I'll make a deal with this subreddit. If this comment gets 100 upvotes, which it really crushed, I will publish an illustrated children's book of classic Cuxmas tales and release it on the same day as Maddox's book, purely out of spite. All right. Update, 12:29 a.m. Okay, we're doing this. Right now, the biggest thing we need is a publishing service that will chart on the New York Times bestseller list. I'm guessing CreateSpace because of its affiliation with Amazon. But can someone help find out? There have to be stories out there, people charting out of nowhere. Publishing a book is expensive as hell. I put out a book for Patreon supporters, and it costs quite a bit per copy. So I'm going to take the advice of you, Maddox Lost, and you, Robotier, and introducing a new $5 reward on Patreon to fund this insane endeavor. $5 pledge will come with DRM-free digital cyber copy of this full color, fully illustrated, soon-to-be seminal Christmas classic. Visit patreon.com/Asterios for deets. Finally, if you want to pitch a story or your art, leave it in the comments. We have a lot of great Cuxmas carols coming from the last thread. Let's make this book the biggest, greatest tome in the history of Cuxmas. How do you allege that that book is defaming or harassing you in any way? Like releasing a book on the same day as your book out of spite? has nothing to do with defamation or harassment. Not at all. So, that's not helpful. Finally, let's see. This is the... Oh, there's... This it? Oh, there's 3 more. Okay, so paragraph 96. This is on page 23. I'm probably going to clip these in. Maybe. I don't know. Defendant Burt, this is... Okay, so this is about Maddox. Defendant Burt regularly appears in the Defendant's Apostrophe podcast. Oh, good job. And throughout their other social media platforms as a developmentally disabled individual who defendants Herrera and Kokonos make fun of as a parody of plaintiff. Defendants promote Maddox and market his content to their followers. See URL, reddit.com, Dick Show, Maddox versus Existence available now. Where Kokonos and Herrera are promoting Burt's Maddox album and defaming plaintiff. Okay, so you're saying that in this post that Dick Masterson and Asterios Kokonos are defaming you. All right. Dick Masterson, I'm on the URL. Dick Masterson is not on here. He didn't post. Good job. So he can't defame you because his posts aren't on here. Asterios has several posts. Okay, so the post is Maddox versus Existence, posted by Maddox. For real this time, deep discounts, $1.99 for the first bonus episode of Bestest Debates in the Universe, a show that doesn't yet exist. Based on a one-sentence synopsis from a Reddit comment referring to George's own bonus episode, Maddox versus Existence is a perfect episode if George were self-aware of what a joke he has become. Available now on iTunes, Google Play, Amazon, needs price adjustment, and Google Music. Groove Music, just search for Maddox. Okay. So, first of all, nothing in that was defamatory. If you say George was self-aware of what a joke he has become is defamatory, like you literally have to become a joke. This is obviously an opinion about you. So, Asterios. And mind you, that was Trevor Burt's statement, not Kokonos and Herrera. That's who you're talking about, is Kokonos and Herrera. And again, Herrera hasn't posted, but Kokonos has. F yes, I'm buying this right the F now. 6:55 p.m. Ha ha ha. He's number 4 on iTunes. Update 1051. Now number 2. Congratulations, Maddox, on making it really high on the iTunes ranking. Asterios Kokonos, brackets, looks over at Cuxmas Carols, brackets, gets angry at it for not being as funny as Maddox versus Existence. Not defamatory towards you, maybe defamatory towards his own work. Asterios Kokonos again. Not yet, but I just bought it on iTunes. If enough of us do, what if Maddox beats Maddox on the effing iTunes charts? It's not defamatory. Asterios, they're really effing good. And that's it. Those are all the statements by Asterios. Not one of them even approaches defamation. None of them are even addressed about you. The next one. Paragraph 98. Like other defendants, Defendant Burt has created a business around his defaming and harassing plaintiff and creating content and inciting his fans to harass plaintiff Azunian. Okay. That's a legal conclusion, right? Defamation. You're in your facts stage. You're supposed to show how he has defamed you, and you don't. Good job. Final one. Defendant Herrera, this is paragraph 109 on page 25. Defendant Herrera tweeted this false negative review to his other fans and boasted about his harassment and defamation of plaintiff's books. So you're not even alleging defamation. You're saying that Herrera is boasting about his defamation and has continued to encourage his fans to follow suit to destroy plaintiff's books and the sales there too. See Twitter link, no screenshot. And that's it. That's the entirety of your evidence. Now, real quick, and I know this video is getting long. All of my videos are long, and I apologize. I talk too much. I like to hear myself talk. Get over it. Or don't. But please do. So let's focus on defamation per se, because that's what Maddox is talking about, right? Is defamation per se. So this is from Sherritt versus Hickey. That's an unfortunate last name. This is July 14th, 2005 in the Supreme Court Appellate Division of New York. Based on statements in the report, plaintiffs commenced this defamation action. At the conclusion of plaintiff's case during jury trial, Supreme Court granted defendants' motion for a directed verdict under CPLR 4401 and dismissed the complaint, plaintiff's appeal. Now this is important. Because plaintiffs failed to prove damages, we affirm a directed verdict is appropriate only where no rational jury could find for the non-moving party based on the evidence presented. Maddox, this is probably your future. Even affording that party the benefit of every favorable inference to be drawn from the evidence. Then they cite a bunch of cases. Plaintiffs in a defamation action must prove special damages, meaning economic or financial loss, unless they fit within an exception in which damages are presumed, i.e. defamation per se. And it directs us to Lieberman versus Gelstein and Hassig versus Fitz-Randolph. And I'll go to those in just a second, but there's a little bit more here that's important. The exceptions raised here are for statements charging plaintiffs with a serious crime or for dishonesty in business matters. Allegations of violating town ordinances or the environmental laws at issue do not constitute defamation per se, because they do not allege serious crimes, but instead constitute the imputation of unlawful behavior amounting to no more than minor offenses which are not actionable without proof of damages. Nor do violations of environmental regulations or the failure to obtain permits impute dishonesty in business dealings or incapacity or incompetence to perform in their trade, even if the alleged violations occurred on plaintiff's business property. Plaintiffs submitted no proof of damages to BVC, even implying that they suffered no damage to their business income. Although there was testimony that after the report was published, plaintiff Dwight R. Sherratt suffered depression, which required medication. Does this sound like you, right? Like you're alleging your emotional distress? No medical proof linked the depression to the report and its repercussions. Causation must be proven, especially in light of Dwayne Sherratt's past medical history. General testimony regarding humiliation, loss of reputation in the community is insufficient to prove special damages. We need not address any other issues raised because based on plaintiff's failure to prove damages, defendants were entitled to a directed verdict dismissing the complaint. You can't just say your reputation is damaged and it's caused you harm in your dealings with the community. That's not enough. You have to prove those damages. So, as stated, it directed us to Lieberman versus Gelstein, which is a case from 1992. And let me get to the citation here. Whoops. Where did I go? Open a new tab. So I had it open, but then I kind of lost my spot. Okay. Slander as a rule is not actionable unless the plaintiff suffers special damage. Special damages contemplate the loss of something having economic or pecuniary value. Plaintiff has not alleged special damages, and thus his slander claims are not sustainable unless they fall within one of the exceptions to the rule. Here are the 4 established exceptions. I can think of one that might apply to you, Maddox. The 4 established exceptions, collectively slander per se, consist of statements. 1, charging the plaintiff with a serious crime. Obviously, Dick hasn't charged you with a serious crime, right? 2, that tend to injure another in his or her trade, business, or profession. This would be discussing like dishonesty in business dealings, not dishonesty. Dishonesty in business dealings. That the plaintiff has a loathsome disease. Do you have a loathsome disease? Has he talked about it? Like leprosy? I don't know. These standards came out so long ago. What's even a loathsome disease anymore? What even is a loathsome disease, Maddox? Or imputing unchastity to a woman. That would be you, right? If Dick called you a slut and you're a woman. I don't know. I think he should. That'd be funny. But of course, like, he can't just decide you're a slut as an opinion, right? He would have to actually impute unchastity onto you. Which would mean, like, he'd have to make factual statements to show that you were unchaste. But I think you've made factual statements to show that you would like to be unchaste if you weren't a virgin. That's... Oh. The rest of this case is regard to the criminal conduct, because the other three standards are really hard to meet. Not every imputation of unlawful behavior is slanderous per se. The extension of criminal punishment to many minor offenses, it was obviously necessary to make some distinction as to character of the crime, since the charge of a traffic violation, for example, would not exclude a person from society and today would do little, if any, harm to his or her reputation at all. Thus, the law distinguishes between seriously and relatively minor offenses. Dick hasn't accused you of a crime, right? He's just accused you of being like a dirtbag, which is fine, by the way. That's an opinion. I don't know if you know. So then the other one is Hassig versus Fitz-Randolph. Here we go. Supreme Court properly dismissed the cause of action against Fitz-Randolph. Since falsity is a requirement of a defamation claim and only factual assertions are capable of being proven false, defamation actions can only be premised on assertions of fact, not opinion. Whether a statement is a fact or opinion must be determined by the court as a matter of law, and it depends on whether a reasonable reader would consider the assertions to be opinion or fact. Although courts generally look at the context of the whole communication, including its tone and purpose, to determine the statement of fact or opinion status, the newspaper article containing the allegedly defamatory statements was not included in the record. Does this sound familiar, how you didn't include any of this stuff in the record? In any event, viewing those statements alone, a reasonable reader would view Fitz-Randolph's statements as mere puffery or as reflecting his opinion rather than fact, and therefore they are not actionable. What are the... Let's see. Plaintiffs, environmental activists who spoke regularly at municipal board meetings, claimed they were defamed by defendants who are county legislators. Specifically, as relevant here, defendant Peter Fitz-Randolph told a newspaper reporter that members of the St. Lawrence County Board of Legislators were all really sick of it. I don't think one person on the legislature gives plaintiffs any credibility or any credence at all. Quite often, we just tune them out or we doodle and we just tolerate them. The newspaper article further attributed Fitz-Randolph with saying the environmentalists are sloppy with the data they present on local cancer rates. Fitz-Randolph also reported to police that plaintiff Donald L. Hessing, hereinafter plaintiff, had threatened his life. Okay. Those statements are kind of similar to you, right? They're either dismissive or paint you negatively as far as opinion goes. Sloppy with data and that they present on local cancer rates, like you're a liar about what has happened, is a similar claim. Like, it goes a little bit farther than saying you're just sloppy, but these are opinions. Just like Dick's claims against you are opinions. So this is what you have to overcome. And, I mean, you failed to do it. Again, if he said it in a podcast, the easiest thing in the world would either be to get a transcript of the podcast or just cite to the minute that he says it. Or quote it. Any of these defamatory statements could be quoted, but you don't do it because you don't understand what defamation is, because everything Dick says about you is an opinion, and anyone listening knows it's an opinion, because when he calls you a piece of shit, we don't think that you're literally a piece of feces. No one thinks that that's an actual factual statement. It's an opinion statement. When he says you're a liar, we think it's an opinion. And also, you've shown a character for lying about things. I don't know, man. It's hard to say that that's a knowingly false statement. It's probably a true statement. But I don't know. That's just my opinion. Now I'm covered, right? So please don't sue me. I mean, or do. I don't care. If it comes out like this, it might produce more content. Probably launch my Patreon. That'd be great. Why don't you sue me, Maddox? Anyway, I didn't intend, I did not intend for going through this short cause of action to be an hour, but, you know, when you look at the law, at how the court has defined defamation per se, because that's what you've accused him of, not just general defamation, you're saying defamation, libel, and slander per se. You've set the bar higher than just defamation. And you've set yourself up for a directed verdict against you, or a summary judgment, or just a dismissal, because none of your claims meet the necessary requirements for libel per se or slander per se. And not only that, even if they could, you don't lay it out properly. You should have laid out the elements for defamation and libel per se in your cause of action and then linked a factual statement to the element. That's how you do a cause of action portion of your complaint. You take a factual statement, you link it to an element of a claim, and then you put it in the cause of action so that the judge or legal aid understands what legal theory you're trying to apply. If you just leave it ambiguous, you're gonna get wrecked by any competent attorney. Like any competent attorney is going to come in and be like, none of this stuff is defamatory. It's certainly not libel per se or slander per se. It can't be because it doesn't fall into one of these 4 categories and it doesn't meet the elements that are required. You're talking about presumed damages, and I assume you're trying to lay it out under the idea that he's alleging that you're incompetent or untrustworthy in your trade or profession, but he doesn't. That's a specific statement. That would be like saying a blacksmith is incapable of hammering out the dents in a piece of metal because he lacks the proper training, right? He didn't apprentice for long enough or something, and then alleging a series. I don't know. It's actually really hard to do it, right? Or if some specific profession like an attorney or an investment analyst or an insurance salesman, like if you suggested that they had a character of untruthfulness and that made them or a violation of trust, and then you showed a history of breaches of trust or untruthfulness, like convictions for perjury, for example, or ethics violations from the ethics board, then you would establish that they're incapable of conducting business, or they're not reliably conducting business to the standards of their profession. That's what you need. Like saying that you are an insufferable autist who can't handle interpersonal relationships and that makes it really difficult to do business with you as a podcaster isn't defamatory. 1, it's an opinion statement. And 2, even if those are factual allegations made, they don't actually cause other people to not purchase your product. Because if you're a successful podcaster, that would be based on people purchasing your product. And me saying he's an autist who's really hard to work with doesn't have anything to do with your finished product, right? That has to do with the interpersonal communications between you and like a co-host or a guest or some sort of staff member. And as long as you're producing a podcast and you can't link the decline of your podcast to statements directly, then you're going to have real problems doing this. And to do that, you're going to have to admit declining sales. Do you have declining consumption of your product, Maddox? Go ahead and admit it. It's fine. We all assume that your product is doing terribly anyway. So why don't you come out and admit it? You should have put numbers that show the impact of each particular statement. Like that's, I mean, if I'm alleging that he's hurting my business, that's what I'm going to do. But you've routinely defended the performance of your podcast. Are the numbers going up? Why don't you publish them and show us? Why don't you publish them? Either you're lying to the court and saying that your numbers are going down based on a direct action of the statement, and they're not going down, like your podcast is growing, and if it's growing, then he can't be harming you with these statements, right? Like that would be obviously contraindicative of what you're claiming, which would be among the other litanies of lies in this thing. It'd be another lie to the court. Or you have to publicly own up to the fact that your podcast is failing. Which one is it? Is your podcast succeeding or failing? If it's failing, you should have ate crow and published the numbers, but you didn't do that. And if it's succeeding, your claim is false and you've lied. Either way, you've shot yourself in the foot on the defamation claim. So anyway, guys, I'm going to wrap this up. I lied. I'm a liar, right? Lawyer, not a liar. Freudian slip. I'm not going to clip in the statements because they're not really long. It takes a long time to edit that. I'm kind of lazy. It's the day after New Year's. Rip me up in the comments for it all you want. That'd be cool. And then if you rip me up sufficiently and creatively, then I'll include them next time. But really, you don't. I mean, you can just read through the second cause of action, and then I told you the locations of the other ones by paragraph number, and they're not really important because the most important thing here, none of the statements meet any sort of legal definition of defamation. So, sorry, Maddox. Cause 2's a bust. Looking forward to Cause 3. Thanks for watching, guys. I really appreciate it. Hope you enjoy this. Let me know if you don't, or if there's something, and I'll be back to Scotch because the stupid bottle of champagne's gone. But let me know if there's something you'd like to see in the comments. Or, you know, you get more credibility if you go on Patreon and gripe at me on there. And I'd love to engage with you guys in either place. So, cheers. Happy New Year's. Here's to the next video.